Alrighty, so this is DC We the People News. One more time at it, y'all. Alright, see if I can straighten this up a little bit more. There we go. Maybe. Who knows? We never look straight forward. We always look around us, be able to protect ourselves by any means necessary. Now, there's a video I did previous about the guy calling a judge a committing treason. Okay? It's actually the same guy. Clerk's Law, Cornell, or Corner. Cornell. All right. And he uses Westlaw. But my understanding, I never used it, is where you can get a lot of American jurisprudence, right? But it's $300 a month. It was designed for attorneys. We can get it, but it was particularly designed for attorneys. And there's some cases that you cannot find, Supreme Court cases you cannot find that you can find on here. You just got to know what it is. They can never make anything easy, right? This is American jurisprudence, and I thought it was interesting to go ahead and hear what American jurisprudence said.
There was a 112.
So,
well,
let's back up a little bit.
Alright. I think it was 111. There wasn't.
Okay, we're going to pause right there so you can kind of read that right there. Alright. Now we'll go ahead and proceed forward. That way you can pause it or go on his YouTube channel, Clerk's Law Corner. Okay?
112. Where the issue is whether particular legislation conforms with or contravenes a state constitution, ordinarily all courts within the state have the power and duty to determine the matter. But the court of last resort of the state is the final arbiter. The state Supreme Court is the final arbiter of the state constitution and may interpret the state constitutional provisions more broadly than corresponding provisions of the federal constitution. They're not the final say, because you can appeal from the state Supreme Court to the Supreme Court of the United States of America. Only a court of competent jurisdiction has the power of judicial review and the solemn responsibility to strike down a statute that runs afoul of either the federal or state constitutions. Federal courts, as a general rule, are inclined to refrain from passing upon the conformity of legislation with the state constitution, since they are usually concerned only with whether state legislation offends the federal constitution. Acts of state governors, however, are reviewable.
Let's pause right there. That's a key word as well. We got to look at key words. The state offends the federal. All right, they're offender. They got to double check and make sure it does not offend the state or federal constitution. All right, Texas constitution allowed to bear arms, right, offends the Second Amendment. It cannot do that. So the Texas Constitution is in contradictory of the federal Constitution. States are allowed to give you more freedom, okay, but they're not allowed to take freedom from you. All right. So I know it's weird how this sets up, but we've been misled.
The lower federal courts, as well as the United States Supreme Court. It's not called the United States Supreme Court. It's Supreme Court of the United States of America. See, again, bar word salad. The United States federal constitution issues can be litigated not only in the federal courts, but also in state courts. That's kind of backwards, ain't it? But hey. Section 112, judicial powers to determine constitutional limit imposes obligatory duty. Okay, this is where it's kind of going to get serious.
I was supposed to say that. This is where it's kind of interesting.
Since the Constitution must be obeyed by the judiciary as well as the other departments of government, and the judges are sworn to support its provisions, courts are not at liberty to overlook or disregard its commands, or countenance evasions thereof. It is their duty in authorized proceedings to give effect to the existing Constitution and to obey all constitutional provisions irrespective of their opinion as to the wisdom or desirability of such provisions, and irrespective of the consequences.
When challenged, the judge must go to the Constitution and see if it coincides with our freedom, people.
Thus, it is said that the courts should be and are alert to enforce the provisions of the Constitution and guard against their infringement by legislative fiat or otherwise. Gee, the judge in my case didn't do that. And I brought him up, and I challenged it. Why? Why didn't he uphold the provisions of the Constitution? Why didn't he uphold the provisions of the Bills of Rights? His butt's going to be in hot water here real soon. Just saying. If a statute violates a mandatory provision of the Constitution, the court is required to declare such an act unconstitutional and void. You are required. The duty of the court in a proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the deliberate judgment of the tribunal before which the validity of the enactment is directly drawn into question. Once it is determined that a statute encroaches on constitutional limitations, the judicial department must not hesitate in condemning it. Thus, there rests upon the courts the affirmative duty of refusing to sustain that which by the Constitution has been declared repugnant to public policy. See? Statutes are policy. Public policy. See, they're in the public. We, the people, are in the private. We are at law. Private. Article 3, Section 2 is in law. That's in the public. Not to be confused with out here in the general public. But see, that's a confusing, I know that's a very confusing thing to say, is private and public. Most people are led to believe that as soon as you walk out your door and you go out here on the streets and highways, you leave your private property, you're now in the public. That is false. We are always in the private unless we engage in the public, which requires a contract and an oath of office in most cases, pursuant to Article 6, Clause 3. Every member of the legislative, executive, and judicial branch, both state and federal, shall be bound by oath or affirmation to support this Constitution. They are the citizens. Whether they're elected or appointed into a position of public trust or not is irrelevant. You're a part of the legislative, executive, judicial branch. You're receiving taxpayer dollars. You shall be bound by oath or affirmation to support this Constitution. In Article 6, Clause 2, the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary are notwithstanding. Marbury versus Madison, 5 U.S.C. 135, right? U.S. 135. Okay? Again, anything that comes in conflict with the supreme law of the land is void for any effect from its inception, void ab initio.
Marbury versus Madison. There's been a lot of debates on that particular case, but how it got started, the original complaint, okay, was due to someone did not have an oath of office. So therefore, they could not particularly give any direct form of orders. That's how it all began with Marbury versus Madison. Of my understanding, I'm not an attorney and not giving legal advice. Okay, it's educational purposes only. So YouTube does not take this down. All right, so that's the original beginning of the whole Marbury versus Madison. Now, when the process went in through there, it kind of got all kinds of diluted and all kinds of things in there, and judges used trickery of words and gave themselves magical powers. And they made themselves kings somehow. All right, somebody went in there and sprinkled little fairy dust on the judges. Let's see what else he had to say on this.
And supporting, protecting, and defending the Constitution by giving effect to the provisions of the Constitution, even if in doing so doing, a statute is held to be inoperative. This duty of the courts to maintain the Constitution as the fundamental law of the state cannot be evaded.
Words. Direct words. Okay? Words matter. But directness, everything cannot be blurred to you. It has to be intentionally, easily deciphered from we the people. You know, we got to be able to read it, and low educated people can clearly establish what it says and means. But they do not do that. They put 10 different definitions in there, and you go by your definitions while they go by their definitions. And then when you go to court, you lose because you're using the wrong definition.
So, this is where I go into trying to teach people about how to bring this stuff up in court. You got to bring this stuff up.
All right, we're going to go ahead and pause it there so we don't make it too long this week. But always recognize when everybody says, well, you broke a law. No, you did not break a law. You broke a statute, a code. Okay? It's policy. Okay? The officers are policies enforcers. The magistrates are policies enforcers. Okay? And none of them looks up the Constitution to see if the policies coincide and married to the Constitution. Okay? They got to be married together to be standing. They must be married together, be able to have subject matter jurisdiction. If it's contradictory, the statutes and the Constitution is divorced. Okay? If they're divorced, then they have no subject matter jurisdiction. So when they say matter in these cases, it's a subject matter. Okay? So you got to read between the lines. Anything that the statute or all these things says matter before, matter here, matter there, matter there. It's always subject matter. They just bypass, leave it blank for the subject. Okay, so anytime you read matter as subject matter. All right, not attorney, not giving legal advice. Do your own research, educational purposes only. Can't believe I had to keep saying these things. All right, let me put the thumbs up because I did like that. And he spends his own hard-earned money, alleged money, banknotes, to require this information. Like I said, last time I heard, it's $300 a month. And Westlaw is designed for attorneys. Me and you, on the average basis, can't get this information because some of it's on public record and some of it's not. There is cases that you cannot find but on here. Supreme Court cases. It's hidden from the public people. Okay, the private people it's been hidden from. All right. Again, sorry. This will be the People News. Till next time. Bye, y'all.